Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Good morning, everyone. I'm Tiffany Thomas, a lawyer here at SpringLaw, and I'm joined here today by Jess Paglia, a colleague of mine and one of the employment lawyers on our team. Thank you so much for joining us this morning, and we're going to be talking about workplace investigations. We know that there's a lot of you joining us today, which we're of course very excited about, and which suggests to us that workplace investigations is clearly a hot topic as we all continue to navigate this post-pandemic workforce. For those of you who are new to our webinars, welcome. For those of you who are not new, also welcome back. We're a virtual Canadian law firm specializing in employment and contract law. We will welcome you to please ask questions throughout the chat, through the chat function. If we can't get to your comments at the end, which we're saving some time for our questions, please feel free to follow up with us afterwards. Our very last slide will be a contact slide. So if you do have any questions, you can use one of the email addresses to reach us there after the presentation. Our slides are available for handout, and you can just download them from the handouts tab. And we also have a ton of great resources on our website, which is springlaw.ca. There you're going to find our award-winning weekly blog, which I know this is a biased opinion, but we have a ton of great legal tips and tricks on there, just some hot topic issues, some things you're probably facing in the workforce that you're curious about, so it's a great starting point. We also on our website have a free policy compliance checklist. We have a link to our monthly subscription newsletter, and we also have our subscription program for employers and DIY legal products if you're curious about any of that. So with that, let's go ahead and jump into a couple of important housekeeping matters. So first and foremost, before we begin the content of our presentation, we're going to take the opportunity to acknowledge that the land on which we operate is the traditional territory of the Anishinaabe, the Chippewa, the Haudenosaunee, and the Wendat, and the Mississauga of the Credit First Nation, who have stewarded these lands for generations. We recognize that Indigenous peoples lived and thrived here long before the arrival of settlers, and we acknowledge the lasting impacts of colonialism. As part of our commitment to truth and reconciliation, we strive to learn, unlearn, and understand the history and effects of these wrongs. We are very grateful to live and work on this land. And of course, because we're lawyers, we need disclaimers. We just simply are not lawyers. So what I'm going to go ahead and leave a legal disclaimer on the screen here for your reading pleasure, and I'm just going to hit some of the highlights. So the content of this webinar should of course not be relied on as legal advice. By attending this webinar, you are not in a client-lawyer relationship with the firm, with myself, or with Jess. When you're listening to the webinar or listening to it in the future in terms of watching a recording, you should really be applying your own judgment in making use of any of the content from this webinar, because this is for informational purposes only, and because every case and set of facts is different, the application of this information in the webinar will not lead to the same conclusion every time. So please apply your own judgment. And finally, because the law changes very quickly, there is no guarantee that any of the information in this webinar will be up to date when you view it at some time in the future. So please do take all this information into consideration, all these disclaimers into consideration if you're attending today or watching a recording in the future. I'm going to turn it over to Jess now, who's going to give you an outline of what we're going to be covering today in our presentation. Jess?
Thank you, Tiffany, and hi, everyone. Tiffany, I'm just going to mention before we start that I noticed the slides weren't changing from our opening slide.
Thanks, Jess. I'll work on that while you kick it off with our presentation roadmap.
Okay, so I'll go through for everyone our presentation roadmap. So I'm going to be diving into what we're covering today. The focus of this session is on workplace investigations, which we know can be stressful, emotional, and, let's be honest, expensive. We'll walk through the essentials of what you need to know to navigate these situations effectively, especially for HR teams or in-house counsel who aren't really sure where to start. So first, we're going to be talking about when investigations are necessary. Not every issue requires a full-blown investigation, so knowing when to take the investigation step is key. Then we'll move on to initial steps, principles, and considerations when conducting an investigation. Getting the foundation right at the start can save you a lot of headaches later on. It's about being methodical and thorough from day one. So after that, we'll go through the hallmarks of reasonable investigations. Next, we'll look at alternatives to investigations. So there are times when an investigation isn't the only or even the best solution. Mediation, informal resolution, or coaching might be more appropriate depending on the issue. We'll also go over best practices to make sure your investigation is not only effective, but is also defensible. And you'll want to be able to stand behind the process, especially if it's challenged later. Finally, we'll wrap up with some common mistakes to avoid. We all know these can derail an investigation or put the organization at risk, so I'll highlight the most common pitfalls. And then by the end of this presentation, you'll have a solid roadmap for handling workplace investigations, both efficiently and defensively. So next, I'll pass it on to Tiffany.
Thanks, Jessica. I'm hoping that most of you can see our slides changing, and if not, we're going to keep working on that behind the scenes to try to sort it out. And in the meantime, let's get going with the content of our presentation. And specifically, we're going to start off with the topic of when workplace investigations are necessary. So typically, sort of a guiding standard of when investigations are going to be necessary are a couple of, big sort of issues or hallmarks that are going to come up. So the first one is pretty straightforward, and it's sort of the easiest. It's when you get a formal written complaint from somebody. They come into your office, you're the HR person in the organization, or they email you and it's an actual formal written complaint. So that's going to be, just one of the ways. Where it becomes a little bit more tricky is it an informal oral complaint or an anonymous complaint of improper behavior, or is it actually just an observation of improper behavior? So are you a manager or an HR person and you happen to be sitting in a meeting or the meeting's about to begin and you hear or see something that makes you feel uncomfortable, right? And so, yes, it's going to come up with a formal written complaint. Yes, it might be an oral complaint, or it might be an anonymous complaint. It might be an observation, but there's also going to be this sort of third situation in which you might have to ask yourself, should I be investigating? And that's going to be sort of an incident that you ought to have known about. And we see this come up frequently in our practice where someone will come forward and say, this is just a historical pattern, or, oh yeah, he's always been like that, or she's always been like that. It might be gossip, it might be a rumor, it's out there. And you have to stop and question yourself as somebody responsible in the organization. I'm speaking to the HR folks, to the managers, to those in the C-suite, to ask yourself, is this an incident that I ought to have known required investigation potentially, right? And so that's sort of the 3 or 4 opportunities in which you need to stop and ask yourself, is this something requiring an investigation? Now, a really straightforward way to frame the test when it comes to, am I obligated to investigate, is the safety of the workplace at risk? And if yes, if the answer is yes, then you likely need to investigate. I'm just going to pause for one moment and say, if you're following along in our handouts, because our tech team's still working to get these slides up, We're on the slide titled When Are Workplace Investigations Necessary? It's slide 8. And so again, this straightforward test of, okay, are these, is safety at risk? Do we need to investigate? Okay. And so if so, again, safety is an issue. Yes, you're likely going to have to investigate. There's one other situation in which I would say you really need to stop and question yourself. Does an investigation need to occur? Which is pertaining specifically to the identities of the complainant and the respondent. And so here, where there's a power imbalance between the parties involved, so specifically between those involved in the allegations, the complainant and the respondent, there's this power imbalance. I think you definitely need to stop, ask yourself, is an investigation necessary? And if so, you know, in consideration of the fact that you do have this power imbalance, I think you can safely assume that your investigation is basically going to be potentially questioned from the get-go on, is this free from conflict given we have a manager? Is this free from any kind of, you know, question of bias? And if that's the case, you want to make sure, which we're going to get into in a little bit, that you're following a consistent formal format for the investigation, and, you know, treating it fairly seriously. There are a couple of common issues we see when it comes to knowing when to investigate in our practice that I just want to pause and highlight, okay? So one of the common issues we see is the temptation or just the reality of sort of sitting on the incident. So a complaint comes forward, or in the past, you've again sort of heard these whispers, or it might even be a sort of open secret. And so we want to be cautious in these types of situations because, number one, you need to understand your legal obligations and you need to know when it's time to act. But you also have to know that, number one, you can't really assume that you're going to be able to investigate a laundry list of bad behavior 6 months down the road, okay? But the other thing you need to understand and certainly consider in these situations is when the complaint comes forward and what sort of the investigation uncovers is that there's this historical pattern of this type of behavior. It's sort of an open secret. This is a pretty serious danger to your organization. So you really have to keep your eyes and ears open and attuned to these potential incidences or complaints, including whether they're just whispers or open secrets, these sort of things, and be asking yourself, does this require an investigation? Okay. Another common sort of issue we see when it comes to investigating and knowing when it's necessary is, you know, you want to be timely and you want to be prompt, which we're going to talk a lot about through this presentation, but at the same time, you don't want to rush, right? There's a difference between being prompt and rushing an investigation. And then the sort of third big issue that I see frequently, and we all sort of see frequently in our practice that I think bears mentioning when it comes to knowing when to investigate is we typically see a lot of great training amongst our HR folks. They know when it's time to investigate. But sometimes that information, that training doesn't always trickle down to the people that are on the ground, the managers, the people that are in the situation day to day that are hearing and seeing things go on. And it's critical that they are actually trained up as well so that they know when it's time to investigate. And it's important because their knowledge of incidents could ultimately be imputed to the organization, which basically means that a failure on their part to investigate, to know when to investigate, could end up being deemed a failure on the organization's part to investigate. So just very, very critical that you're considering all of these sort of issues and making sure that information trickles down to the managers. With that, I'm going to turn it over to Jess, who's going to talk about when you're legally required to investigate.
Thank you, Tiffany. I'm just going to orient myself in our presentation.
You gotta love tech issues, right? We can't live with it, we can't live without it, and we just have to respond in the moment.
Exactly. I think I'm at the right point now. So thank you, Tiffany. Let's get into when and why you have to investigate when workplace harassment or discrimination issues come up. So these are situations where investigating is not optional. It is required. So the OHSA makes it clear that employers must ensure that an investigation is conducted into incidents and complaints of workplace harassment. You and your organization have a legal obligation to investigate every complaint or incident when regarded in these scenarios. It's about taking every precaution reasonable in the circumstances to protect your workers. Under the Human Rights Code, the duty to investigate isn't just to check a box. It's to ensure that people's rights under the code are upheld in a meaningful way. The case law has established that you don't have to have a perfect investigation or conduct a perfect investigation, but it does need to be reasonable. And the duty to investigate arises in two ways. So the first way is that you have a general duty to provide a workplace free from discrimination or harassment. This includes not letting any of those acts slide. The second way is that you must investigate any allegations that you're aware of, or even those that you should be aware of, and as Tiffany mentioned. The seriousness of the complaint will drive the seriousness of your response. The more severe the allegations, the more thorough the investigation needs to be. So by investigating, you're protecting yourself and the business. If you don't investigate, you're leaving yourself open to claims that you failed in your duty to provide a safe workplace. And that could lead to complaints with the Ministry of Labor, the Human Rights Tribunal, or even a lawsuit. And on top of all that, handling these situations will help you retain employees because they'll feel safe. People are more likely to stick around if they feel that their complaints are being taken seriously and being dealt with properly. So now I'll hand it off to Tiffany.
Thanks, Jess. So I'm actually going to talk about some of the initial steps to take when allegations or these incidents arise. So Jess, if you could flip to the next slide for me so that everyone can sort of see the important points here. And so, to begin with, what's really critical that you understand is that the language in, for example, in Ontario's Occupational Health and Safety Act, it refers actually to both complaints and to incidents. And that's important to take into consideration, right? Because the first step or the initial step when these sort of issues arise is to ask yourself, okay, this has happened. Maybe it's not a complaint yet, but could it be considered an incident? Or could it be considered a complaint at some point, right? And that's going back again to this consideration of, should I be investigating? Should I have known to have investigated at this point, right? And so what we're getting at here is it's a fairly broad, broad consideration. It doesn't say in our legislation a formal written complaint. It says complaints and incidents, right? And so you're keeping in mind as sort of this initial first assessment, okay, is this potentially a complaint or an incident? So let's assume for a moment that it is. You've checked in with yourself, this is potentially a complaint or an incident. Next, what you want to be considering is, well, how serious is the allegation and how complex are they, right? And the reason why we're assessing this is not because we're going to say, well, it's not serious, it doesn't warrant an investigation. That's not it, because as Jess just explained, you're legally required to investigate in many circumstances, right? We're checking in with, how serious the allegations are and how complex, because what we're guided by is how, in terms of the investigation, what's appropriate in the circumstance. So if it's a very serious allegation, it's a very complex, which we often see, someone comes forward with sort of many allegations about one person. It's not just one incident that's particularly complex, or the allegation is very serious. It involves, a top decision maker in the organization, or it involves a very serious complaint. You have to use this as a guide to decide, okay, what's appropriate in the circumstance when it comes to my investigation, right? And so I think what happens in a lot of situations, which is totally understandable, is we get this complaint and we the immediate thing we do is think, oh no, or we panic, right? But there are circumstances in truth in which it's a fairly straightforward allegation, or it's one instance or one comment, and it's not particularly complex, and it's not an extremely serious situation. It might just be an offhanded comment, still hurtful, still problematic, all of those things. But what I'm getting at is it doesn't have to trigger the most complex and the most heavy-handed investigation of all time. Sometimes it can be pretty straightforward, right? The next sort of question you need to ask yourself is, who needs to be involved, how many of members of my organization are going to be involved in this. And really it comes down to, again, who needs to be involved, right? And so it may be that you're working in a very small organization, and maybe this was, you know, said in a meeting, so sort of everyone in the organization was a witness to the incident. And so in that case, okay, that pretty much answers your question. Probably most people are going to be involved. Now, does that mean they're involved in the nitty-gritty behind the scenes portion of the investigation? Of course not. Does it mean they're going to be a witness? Probably, yeah. But, you know, in terms of a guiding feature of these, you really just want who is necessary to be involved in terms of especially the behind the scenes investigating, right? Next, you really want to consider each party's perspective. And we would encourage this because this sort of goes to the heart of fairness, right? Now, when you're putting yourself in, you know, each participant's shoes, this isn't the final word on what's right or fair, okay? But it's a good starting point to say to yourself, if I were in this position, how would I want to be treated? And I think that sets you up to really think carefully about the sorts of requests that they're going to come forward with in terms of what they need from this investigation. For example, do they need a support person? Does the complainant need the opportunity to flesh these allegations out in writing? And I think it sets you up to think about them carefully and then respond thoughtfully, which is of course very important. Right along with that, though, is this notion of communicating throughout the investigation. And I see this frequently in my practice where a lot of discontent, a lot of acrimony sort of stems from a lack of communication during the investigation process itself. So you are going to be busy when you sort of start these investigations. You're going to have a lot of work to do, but and so it's sort of human nature for that communication to go to the wayside, but it is also critical that you leave the lines of communication open. And even if you don't have that much to say when it comes to a substantive update, when you're getting these emails or you haven't spoken to the complainant or responded in a long time, send them an email, let them know, I'm working through this. I'm in the process of, you know, for example, broadly, generally, you don't need to give them key specifics, but I'm in the process of talking to a witness or, you know, your list of witnesses. I'll be in touch as soon as I can, right? Again, a lot of acrimony comes from when no one is keeping the complainant or respondent up to date, okay? Keep in mind, as stressful as this is for you, it's also stressful for the participants, both for the complainant, the respondent, and for the witness. So what I would say is plan out your messaging from the get-go, know when you're going to check in with people, know how you're going to keep them updated. Finally, another sort of initial step before starting the investigation, and again, this is a little bit biased coming from a lawyer, but I have to say you need to consider a strategic legal consultation, okay? The investigation is going to take up a good chunk of whoever's conducting the investigation's time, but it's also going to take up a lot of time for the person who's giving instructions on next steps related to the investigation, those sort of things. And so a lawyer can come in, really they can stay in the background, but help you guide you through the process if that's what you're looking for. We can help you sort of assess risk and give options upfront, right? So we can help you assess, do I need to investigate? If so, what does this investigation need to look like? What's appropriate in the circumstances given the overall complexity and seriousness of the complaint? Okay, we can also help you sort of think about what workplace relationships and dynamics are at play and how that might impact your investigation. But we can also help you, once you've gathered all the facts, we can help you apply the law and the legal analysis to those facts when you're thinking about a conclusion, right? And so again, what I think the strategic legal analysis does is set you up for success from the get-go, because it's important to understand that what can and often does happen is that the subject of the investigation, the actual allegation, becomes a complaint, okay? And then what ends up happening, part and parcel with that, is that the investigation itself becomes a part of the subject of that complaint, right? And so when your process is right, when it's defensible from the get-go, you're setting yourself up for success when it comes to a potential complaint coming in. With that, I'm going to turn it over to Jess now, just to talk a little bit further about some further pre-investigation considerations.
Thanks, Tiffany. So once you've decided that an issue requires a formal investigation, there are a few key decisions to make before you jump in. First, you need to decide, should the investigation be internal or external? So if internal, make sure that the investigator is far enough removed from the issue. It's not just about avoiding actual conflicts of interest, but also avoiding the perception of conflict. If the complaint involves a senior management, like a C-suite executive, it's probably better to bring in an external investigator. And we say that because you don't want any questions about fairness or impartiality down the road. So if you stick with internal, then you have to ask, who will lead? Make sure that it's someone with enough bandwidth. We've seen situations time and time again where the HR person that's conducting the investigation is already overburdened, trying to fit in an investigation on top of everything else, and it just leads to unnecessary delays. If the internal investigator's schedule is not cleared for the work, everything will drag out. And we know that these things can't afford to take months to wrap up. So if you go with an external investigator, think about who the organization will work with. It's important to select someone with the right qualifications and to designate a person internally as well, who will give clear instructions to that external investigator. So this person needs to understand the process and stay involved enough to ensure that things move smoothly on the internal side. No matter who conducts the investigation, whether internal or external, you must ensure that they are trained and experienced in conducting investigations. So check if it's an external person, check their professional background, check their track record with similar cases, and these will often be the things that will influence your decision into selecting an external investigator. And if it's internal, you also have to do the same. You have to ensure that this person has experience in conducting investigations. And if you have no one on your team that has that experience, you might want to go external, learn from the process, and then go forward. So you also have to ensure that the person who conducts the investigation is competent and knowledgeable. They should understand the legal issues involved and be able to spot any potential pitfalls. And this, as Tiffany said, this is also another area where you might consider consulting external legal counsel just to understand your legal issues and ensure that you're abiding in the best way that you can. And finally, the person that conducts the investigation should be impartial, neutral, and objective. We keep saying this, but it's so important. Their conclusion should be based on the facts and not influenced by any prior relationships or any knowledge prior of the people involved. So getting these pre-investigation decisions right will help ensure that the process is both effective and defensible. So now I'll turn to Tiffany to continue with the pre-investigation considerations.
Thanks, Jess. Yeah, I'm going to talk about a subject that's very near and dear to my heart, which is your workplace policy. And so this is just, another pre-investigation consideration that you do want to check in with, because it's very possible that the organization does already have a policy on, whether it be specifically harassment, workplace violence, or discrimination. And, hopefully some of those investigation considerations are actually outlined in that policy. And so I'm going to pause and say something, that I think is very important here, and I'll explain why in a minute, which is if, you go and you take a look at your policy and either it looks super out of date, sometimes there will be a day, or you can just sort of tell that this hasn't been updated in a while, or you're aware of the fact this sorts of policies have not been widely distributed. These are sort of warning signs, okay? So it's really critical that you check the policy, and if it's out of date, that you get it up to date. And by up to date, I mean in line with the legal requirements of these policies under your provincial laws, okay? You also want to make sure that your employees know where to find these policies. So it might be in their employee handbook, it might be on an intranet, but you want to make sure that they actually know where to track these policies down. And when you have a policy that's up to date, that's in line with all legal requirements, and that's obvious for your employees to know where to find it, what's great about it is it helps your employees know what to expect. It completely demystifies the process for everyone involved, because if it includes sort of a process, you know that everyone sort of knows what happens next, but it also keeps things consistent, which is important, right? That when your investigations are being critiqued from the outside, potentially, that, you know, if they're consistent, so long as everything is legally, you know, up to date, chances are it's going to be less difficult for them to critique and say, oh, there was bias here, there was conflicts here, and that impacted the process itself. So some of the things that you'd be looking for in this policy are going to be, okay, is there a particular process required to formalize the complaint? So does it require a written complaint? Is oral okay? Does it, you know, can it be anonymous? All those sort of things. And I'll pause here to say, you know, if you receive an oral complaint, this is sometimes a question we get, well, my policy says written, but I got an oral complaint, how do I handle this? You know, in a lot of cases, we're going to suggest maybe you consider getting the complaint formalized, memorialized in a written document. It's not about making the employee jump through hoops, because this is obviously already a tough situation for all involved. It's just making sure you have a fulsome understanding of what the complaint actually is, giving them that opportunity to think, okay, does this cover all of, you know, what I feel has happened? Especially if it's particularly complex, there might be a couple of different allegations at play here. So giving them that opportunity to completely flesh this out in a written document isn't a bad idea. But again, it's not about this notion of, yeah, I'm making you jump through this hoop. It's about, you know, procedural fairness, a fully fledged complaint that's fully particularized, but also keeping consistent with your internal process. Okay. Another sort of thing that you're looking for in this policy is, does it include a threshold assessment? And I'm starting to see these more commonly in workplace policies, not legally required, but sometimes they're important to consider. So does it include, you know, a first process in which we review your complaint and decide, is it going to be investigated? Sometimes those are included in policies, important to check for them. You need to check, does it include, you know, any reference to who will investigate this? So again, you don't want to waste time going down a rabbit hole of who's going to be my investigator and are they qualified if your policy happens to set out who that person is going to be. Your policy might actually include what steps are required to complete the investigation. So sometimes it will pretty much outline exactly what's going to happen once the complaint is received. And there also might be a timeline in there, right? And that's often forgotten about, but there might actually be a timeline that basically says this has to be completed within, you know, 60 days. As somebody who frequently represents both employees and employers through an investigation process, for me, the policy is something I immediately look at on both sides. What I will say about being on the employee side of things is I look at this and I consider, is this policy up to date? Do they have all the legal requirements? And if you don't, employers, I have to tell you, it's a pretty easy area of attack for somebody who's on for an employee to say, hey, you know, there's nothing in here that tells them how to complain, who to complain to, how to go about this, what they can expect, or even more kind of dangerously, which we do sometimes see, this person went through something really serious and they actually didn't even know who to complain to because they couldn't find your policy, right? So those are all things that we're looking for. Again, if you need, you know, to go and take a look at these, here are some of the things that you want to be looking for in terms of a legal requirement, right? Does your policy include measures and procedures for workers to report incidents of workplace harassment to the employer? Doesn't it also include measures, though, for them to report if the person that they are reporting against is the person they would normally report up to, right? So if they normally report to a manager, but the complaint is about a manager, who else are they reporting to in that situation? Because you don't want to be caught in the situation of, well, I couldn't complain because you told me to complain to the person who's actually the harasser, for example. Does your policy sort of set out the incidents and how they will specifically be investigated? how does it deal with things like confidentiality and disclosure? And does it address how this is all going to be concluded in terms of how is the complainant and respondent actually going to be informed of the outcome of the investigation? And what about corrective action? Are they going to be told about those? So those are just some of the things that are legally required here in Ontario that you really want to, be doing an audit of your policy and making sure they're including. I am going to turn it over now for Jess to talk about, sort of some of the hallmarks of what a reasonable investigation looks like. We've now talked a lot about sort of some of the pre-consideration, but what might this look like from the outside, and what might a reasonable investigation look like when you're ready to undertake one? Jess?
Thanks, Tiffany. So we've covered a lot of the prep work and the decisions that need to happen before you start an investigation. So now we're going to take a bird's eye view of what a reasonable investigation looks like step by step. And just keep in mind that each investigation requires a different set of procedural rules and things like that for you to follow and considerations, and different things come up all the time. So this is just a framework to guide you on things that are important to implement and to keep in mind. So first, the investigation needs to be prompt. As soon as you're aware of the potential misconduct, you shouldn't wait. Start the process as quickly as reasonably possible. Delays can often make things a lot worse, whether that's because the evidence fades or trust breakdown. And again, different situations require different approaches. We've seen many times that complainants or respondents are on leave or vacation shortly after things come to light, or even during. So just every situation needs to be approached differently, but just ensure that promptness is at the forefront of what you do. So next, it must be compliant with your policies and legislation. So as Tiffany explained, does your internal investigation policy outline who conducts the investigation or how it's structured? And you should ensure that each time you have to proceed with an investigation, that you're following this policy outline to ensure that there's no bias. The investigation must also be neutral, unbiased, and thorough. This means that you should choose someone who doesn't have any stake in the outcome or any appearance of any stake in the outcome, and has the competence to handle the investigation. So sometimes this might mean bringing in an external investigator, as we spoke about earlier. So procedural fairness is critical at every stage, and here's how that breaks down. First, the complainant needs a clear opportunity to explain their allegations. Now, this is regarding as well that sometimes you might get an allegation that's an anonymous complaint. And so you just need to ensure that either your policy or everything that you do to carry out the policy ensures that the complainant has an opportunity to explain their allegations. Now, this carries into the next procedurally fair point, which is that the respondent or any person accused in the complaint needs to know exactly what they're being accused of with specific details and not vague generalities. So I've been in situations before just observing an investigation where the investigator will actually, based on the complaint, if it's vague or if it doesn't have enough specifics, will actually pre-interview the complainant to just ascertain more of what those complaints are about, or what they're getting to, so that the respondent has a more clear picture of what they're responding to. And then both sides should have the opportunity to provide supporting evidence, whether that's emails, documents, or witness testimony. And you or whoever's being involved internally in helping conduct the investigation or in conducting the investigation should ensure that each side has the opportunity throughout the investigation to provide supporting evidence, and that everyone involved has enough time to review everything they have and to submit it. So it's also important to interview any relevant witnesses. Do not skip this part. This part is very important because it helps ensure that the investigation is thorough and fair, and it gives the investigator a further understanding of what happened, the context, and these details that might have been overlooked from the perspective of the complainant or the respondent. You should also make sure that everything is well documented. So this is everything from the allegations, the interviews, the evidence, notes, all the way to your conclusions. This documentation will be crucial later if the investigation is ever challenged, and it's not a requirement, but it is best practice that you should have someone in the involved in the investigation that's specifically designated for note-taking during these interviews and during things like that. So it's not a requirement, but if you do have the bandwidth, it alleviates some of that burden of documenting. Finally, once you've gathered all of your evidence, you have to conclude based on facts. So you have to reconcile everything fairly and without bias. And then after the investigation is complete, you need to take appropriate corrective action if needed, as Tiffany mentioned. And you have to communicate the outcome to both the complainant and the respondent. And transparency here helps maintain trust and closure on both sides. So now this communication, you don't have to provide everything that you've discovered throughout the investigation to each party, but you do need to provide them with some kind of conclusive, results-based and fact-based outcome of what has happened. So this is the big picture process. Getting these steps right will ensure that your investigation is not only reasonable, but it's also defensible if it's ever called into question. So next I'm going to turn it over to Tiffany to talk about the general principles of the investigation.
Thanks, Jess. That was so helpful. And I'll just pick up on one point that Jess mentioned, which is, again, documentation. Really can't overemphasize how important it is to document, your efforts during the investigation. If you're going into a witness interview or an interview with the complainant or respondent, make sure you or hopefully someone is taking notes on your behalf. It's really important to have as complete notes as you can, because again, once you get to that stage of coming to a conclusion based on facts, you want to be able to look back on those things and say, well, what exactly did the complainant have to say about that? How did it differ to what the respondent said, so that you can come to a defensible conclusion on those things. It's hard to do without really complete notes. So again, if possible, have that note taker. If not, you have to do the work yourself and make sure that everything is carefully documented. So now that Jess has sort of given you this bird's eye view on the hallmarks of sort of a reasonable investigation, let's talk about some of the general principles that you're going to apply as you investigate, as you do this sort of reasonable investigation. So the first sort of general principle is going to be to investigate in a way that's expeditious, fairly, and decisively. So when we say expeditiously, again, this has come up a lot, but we're being timely in response to the complaint and then throughout the investigation process. We all know that good things take time, but this is a really highly charged situation for everyone involved. You have a complainant who's awaiting an outcome, who's waiting to find out how this, potentially really difficult situation is going to be resolved. You're also dealing with a respondent who is being accused of something that they may feel is unfair, that's untrue. They may feel their reputation is being impacted as a result. They might be off work. There could be a whole number of things at play. So you want to be cognizant throughout that timing is on everybody's mind, and you want to be approaching each and every step of the investigation, the initial response, the interviews, the report, the outcome letters, everything in a timely way. Again, as I mentioned earlier, there's a difference between, being expeditious and rushing. We're certainly not suggesting you rush the investigation, but, ensuring that adequate time is set aside to handle this in a prompt way. Decisively, what we're getting at here is, what is the complaint? What is the scope of the complaint? And what is the mandate of the investigation, right? And so I think people who are doing their first investigation will realize quite quickly on into the process that investigations can go off the rails very, very quickly, right? So you sit down for an interview with a witness and they'll say something like, well, I don't want to, I've never seen the respondent do this, but I have seen the respondent do this, right? You want to know from the get-go, what exactly is your scope? What's this complaint about? What are you going to do if new allegations like that do come up? How are you going to handle it? Is going to become part of the investigation? Does that person need to make a complaint? These are all things you need to sort of decide at the outset of the investigation and keep checking in through the process, right? Because again, they can go off the rails, but then there can also be a question of, well, how thorough was this investigation? Turning to sort of a fair investigation, which Jess talked about quite extensively when it comes to procedural fairness. Well, what does that really look like as you're investigating, right? So where I think this starts is is the complaint itself and are the allegations fully formed? There's nothing more frustrating for a respondent or potentially more unfair to a respondent than trying to respond to a bunch of allegations that have almost no specifics. So, oh, at some date, at some time, something like this was said. That's really hard to respond to, especially if it was a couple of months ago, right? So do you have as many details are as available? It might be a situation where the complainant truly doesn't remember the date or time, but can you push them and say, well, can you remember a month? You know, is there a particular event you remember happening around this time? Can you put the pieces together in terms of when that might have happened, right? Because it's critical when it comes to fairness that the respondent really understand what they're responding to. You also want to ensure when it comes to fairness, like, has everyone in the process had a meaningful opportunity to explain what has happened from their perspective? And has the investigator then really considered the totality of the evidence in a fair and unbiased manner? So if they shored everything up at the end of the investigation and come to a conclusion based on those facts, but taking into consideration the totality of all the evidence they've been providing. And then tying in directly with fairness is approaching and conducting this investigation in an objective and neutral manner. So you really need to come to this and set aside the things you know about everyone involved. So commonly we see this come up where there will be considerations about what type of performer people are. If this is a harassment investigation, whether or not somebody's a great workplace performer, whether they're meeting their sales targets in a particular month, probably not going to be all that important, and questionable whether you're letting something about someone's performance sort of color the way that you're approaching, say, a harassment investigation, right? Also, same can go for the fact, have you had a personal really negative interaction with that person? Is that going to color your view of whether they've engaged in this particular conduct? And if so, maybe it's time to step aside and let somebody else investigate. So having those things in mind from the get-go. I'm going to just touch briefly on some of the common questions that arise in our practice pertaining to these sorts of general principles. So when it comes to acting decisively, we get a lot of questions around, well, how formal does the investigation need to be? Again, go back to what's appropriate in these circumstances, right? Again, might be a fairly straightforward complaint, doesn't need to be the most, serious investigation process of all time. We also get questions a lot about in terms of decisively and being decisive in terms of what do I need to investigate in terms of, in your performance managing an employee and they claim this as harassment, or there's a rude comment made, or insubordination. You really need to ask yourself, is this something that's engaging my legal requirement to investigate, or is this just sort of inappropriate conduct? Sure, that might be subject to some discipline in the future, but does this need to be a full-blown workplace investigation, or is this something that can be, handled in an appropriate way? When it comes to approaching these fairly and objectively, one big question I think you need to ask yourself, and one that comes up a lot, is, does your culture allow for a complaint to be made, right? And so I know that can sometimes be a difficult question to ask yourself as an HR or folks or as a manager, but are you operating an organization that would really allow a person to feel comfortable to come forward and make these complaints? And if not, how are you going to adjust that? Jess is going to talk in a minute about some alternatives to investigation, that, there's some tips in there that you may need to check in with in terms of if you feel like you're operating in a culture where maybe someone wouldn't feel comfortable coming forward with in a complaint. Another question when it comes to fairness and objectivity that we encounter a lot is, can you really promise confidentiality to the participants in the investigation, whether that's the complainant or the witnesses, right? So see this frequently where some complaints are coming forward about a manager, and sometimes there is this perception on the behalf of the participants that they're going to remain anonymous forever. And that's something you need to consider from the get-go in terms of, is this really something I can promise? The answer is typically no. And so, right, you need to understand that sort of from the get-go. And finally, in terms of fairness, other common questions we get is, what sorts of evidence can I ask for? How far can I go with that? And how do you handle these questions about a support person being involved in the investigation? Your policy might allow for it, and how do I handle that if so? So those are just sort of some of the common questions that come up and some of the things you're going to need to check in with yourself when it comes to the investigation. I'm going to turn now and let Jess talk about some of the alternatives to investigations, along with some of the best practices and pitfalls to avoid when it comes to investigating.
Thanks, Tiffany. So I'm going to talk next about alternatives to investigations. And we've talked a lot about investigations, but sometimes an investigation isn't required or the best approach. So we're going to look at some alternatives to formal investigations that could address workplace issues more effectively. And just as a reminder, this is not in consideration of the legal obligation to investigate discrimination or harassment. This is for that third option where they kind of, they fall outside of that scope potentially. So the first up is a cultural assessment. So the cultural assessment is less about digging into a specific complaint and more about reviewing the overall workplace culture. You can interview current and former employees to get a sense of the morale, the leadership, and the day-to-day experiences. And from there, you can have a broader understanding of any underlying issues, along with any recommendations for improving the workplace. And this is very compelling just to address anything that might be causing an issue in the future. So this is a great first step. So next we have performance management. If the issue involves poor performance or behavior that doesn't quite rise to the level of misconduct, managing an employee's performance could be a better fit than launching an entire investigation. So this includes setting clear expectations, clear timelines for the employee, and providing feedback as necessary, as well as assistance to improving performance management. And we can talk about that another time, but that's also a different tool. Coaching is another useful tool, especially for managers. So sometimes the problem is that managers don't know how to spot or handle complaints very early on. And coaching can help both employees and managers navigate any difficult situation before it escalates into a complaint. So there's also mediation, which is particularly effective for interpersonal conflicts and those situations where people just, aren't working well together or things like that. So mediation brings both parties together with a neutral third party to work through the issue and reach a resolution. It's often quicker and less formal than a full investigation, and it can lead to a better outcome for everyone involved. We find often in these situations, either the complainant or the respondent, they just want to have their opinion heard, and they just want to have kind of a platform to voice the things that they're going through. Finally, sometimes, unfortunately, early termination is the right solution, either with or without cause. Now, this is in situations where the HR kind of sees ahead of time that someone is just acting in a way that's inappropriate, or that's, that could be construed as misconduct or things like that. And just as, just like acting and ahead of things that will happen. So this can be a cost-effective and an appropriate way to resolve certain situations. It's very, very imperative, very important to get legal advice before making any decisions in this regard, because you want to ensure that you're handling any termination correctly and not exposing yourself or the organization to further risk. And remember that even when you're considering these alternatives, it's important to keep in mind your legal obligations. So your legal obligations as in your legal obligation to investigate. Now, these options can often resolve issues without the need for a full-blown investigation if it's appropriate in those circumstances. So next, I'm going to talk about best practices. So best practices during an investigation, these apply even if you're not the one actually conducting these investigations. And these are critical to ensure that the process stays on track and is ultimately defensible, as we've talked about. So firstly, you need to make sure that confidentiality is maintained to the best of your ability. So remind all the parties and the witnesses that they need to keep the details of the investigation confidential. Now, this helps protect the integrity of the process and prevents any unnecessary gossip or interference with the investigation. Next, you need to take steps to prevent reprisals. This is very important, and you need to be upfront and clear about this. So you need to let your employees know at the start and at the end of the investigation that any retaliation or negative actions against someone for participating in the process will not be tolerated. And you can reinforce this in any reporting letter that you provide at the end. So next, about internal communications. And even I would like to add internal communications as well as your notes, any notes that you take regarding the investigation. We encourage you to be mindful of the content of these internal communications or these notes. Don't leave a trail of emails or comments that could suggest bias or predetermination. So we see these things a lot, things like, an internal message to a colleague saying, here we go again, or, obviously so-and-so, this is happening, or this is taking forever. These comments might feel harmless, but they can come back to haunt you if the investigation is ever scrutinized, because most internal communications and notes regarding an investigation are not privileged and are producible in litigation. So you should assume that everything you put in writing could eventually be seen by a third party. And finally, maintaining procedural fairness throughout the investigation will give you a stronger and more defensible employer response. If everyone feels that the process was fair and unbiased, you're less likely to face further issues down the road, and it often leads to better outcomes for everyone involved. And these practices help ensure that the investigation is not only thorough, but it also stands up to any challenges later on. And so these are just some mistakes to avoid. So these are some of the do's and don'ts that can make or break the process. The first one is a big don't, failing to provide particulars of the allegations in advance. So we've discussed this multiple times, but if the respondent doesn't know the specific details of what they're being accused of, the investigation risks being seen as unfair. So you should always provide enough information so that the respondent can respond meaningfully. Another major issue that we see is if the investigator isn't impartial or is even perceived as being biased. This can destroy entirely the credibility of the process. Make sure that your investigator is neutral and isn't connected in any way that raises any red flags about their objectivity. You'll also want to avoid any evidence of prejudgment or predetermination. So as I mentioned earlier, this means no emails and no internal conversations and no notes that suggest that you've already made up your mind. And we talked about this earlier, things like this again, we know how this will go, so-and-so, this, that. It can undermine your investigation if it ends up in court, and just be mindful of avoiding it entirely. When it comes to the process itself, make sure that you're balancing efficiency with thoroughness. Don't cut corners. If you don't follow up on key witness statements or you leave gaps in the evidence, you're opening yourself up to claims of procedural unfairness. But on the flip side, dragging out the investigation with unreasonable delays and unfounded delays is also a mistake. So timeliness matters, but not at the expense of doing a thoughtful and thorough job. In summary, these are some common pitfalls that can really hurt the integrity of an investigation. By keeping these do's and don'ts in mind, you can ensure that your process is fair, effective, and defensible in the future. And I'll turn it to Tiffany now to wrap it up.
Thanks, Jess. Yeah, so just in light of our time winding up, just a few sort of key takeaways from our presentation today. So, when you're faced with a complaint, the first step is really to decide if you need to investigate and then assess the seriousness and complexity of the allegations or incidents. So again, when it comes to assessing, likely general good rule of thumb is the more serious the allegation, probably the more serious the response, more serious the investigation. But again, you're always guided by this question of what's appropriate in the circumstances. We've given you some of the hallmarks of the reasonable investigation that you can return to. Again, giving everyone the opportunity to respond fairly, giving them those opportunities, and then stepping back and assessing all of your facts to come to a conclusion that's based on those facts and that's defensible on the basis of those facts. We've given you some alternatives to investigation. You know, these are incidences in which you might not need to investigate, or maybe you did, and now you want to sort of bring some, you know, harmony back to the workplace. So thinking about a workplace assessment, thinking about mediation, and ultimately just addressing what's appropriate and then moving forward with that plan, right? Being transparent, communicating with the participants, and supporting the parties, considering what they want, but also knowing what's legally required in the circumstances. And again, just to re-emphasize this notion of procedural fairness, treating the parties the way you would want to be treated if you were in their shoes. It's not the end answer, but it is an important consideration. And ultimately, it really leads to a better outcome and a more defensible employer response when your investigation is overall just completely you know, procedurally fair. We've gotten a ton of great questions. We're nearly out of time. I've gotten a couple of good ones about what sorts of evidence you can ask for. You can certainly ask for the evidence that makes sense in the situation. So a really easy example of this is if an allegation comes forward and they say, oh, and by the way, they made this comment over Facebook Messenger because we happen to be friends there, or they made this comment in a Teams chat, or they made this comment in an email. Those are documents you want to be asking for, right? So at the end of the day, you want to be asking for evidence that's supported by the allegations, supported by what they're saying in an interview. You're not on a wild goose chase or a fishing expedition of everything in their possession. But again, anything that's going to support their sort of side of the story, and that's going to help you come to a conclusion. We also had some great questions about, you know, people who want to remain anonymous. How do you approach that? What I would say is generally probably a best practice to just let them know that you cannot guarantee anonymity throughout investigation, right? There could actually be a situation in which unfortunately your investigation gets to the point where it's being scrutinized in a courtroom. They're not going to remain anonymous, right? Like there's just no ability for you to 100% guarantee that if a judge decides that things are going to be scrutinized. So we're out of time for today. Thank you so much for joining us for today's webinar. Our next webinar is on November 20th at 10:30 a.m. That's Eastern Standard Time. It's covering Employment Contracts 101. So it's going to be a great webinar on something that's super important for a whole number of reasons to your workplace. Feel free to follow up with us on any questions. And again, for more information, you can visit our website, which is springlaw.ca, or follow us on social media, or sign up for our newsletter to stay updated. And we'll see you next month. Thanks so much for attending, everyone. Bye for now.
Thank you.